Okay, final part of Chapter 7, Criminal Liability. I'm outside now because I came out here so my little girl could play on the playground, and you'll see that she's now right beside me coloring. Say hi. Hi. We'll see how this goes. Okay, so defenses to criminal liability. As I mentioned before, the state has the burden of proving your guilt beyond a reasonable doubt. So the defendant, the accused, doesn't have to prove anything. They can just sit back, essentially. They don't, but just sit back and let the state prove their guilt beyond a reasonable doubt. Now, you know, if they're trying to prove really that they didn't do it, all they're trying to do is poke holes in the prosecution's, you know, their story or their timeline to create some of that doubt. So that's all they need for a jury not to convict. But in the event that somebody did the act, but they're trying to prove they didn't have the intent, there's several defenses to being criminally liable. So, sure, the act was done, but here's the reason why the act was done, and it shows I didn't have the intent. And remember, if you don't have the act and the intent, there's no criminal liability. Number 1, self-defense, a very common one you've probably heard of a million times. Self-defense is the privilege to take reasonably necessary steps to protect oneself, another person, or one's property. Okay, so you have the right to take reasonably necessary steps. So again, the jury is going to look at, was it reasonable? The steps that you took, you know, what you were fearful of versus what you did in response to it, was it reasonable? I don't know. That's for the jury to decide. But if it was, then you can claim self-defense and be free of any criminal liability. Number 2 is necessity. Necessity, what it means is what you did was necessary in order to prevent or avoid a greater wrong. So whatever act you did was necessary in order to prevent or avoid a greater wrong. Sure, you assaulted someone, but it was to avoid that person from killing somebody else. So you were trying to prevent a greater harm. It was necessary. Number 3, you hear this one all the time, insanity. Insanity, really what that means is the act was committed, but the person lacked the sufficient mental capacity to know what they were doing, to appreciate the wrongness of what they were doing. So they didn't have the intent because they lacked the mental capacity to have that intent. So there's a complete defense. Number 4, mistake. Keep in mind, this is mistake of fact, not just ignorance of the law. Yeah, so you can't just say, well, I didn't know it was a crime to do that. No. It's not just that you were ignorant of the law. You were mistaken on a fact. Okay, not the law. Number 5, duress, and this is one that you need to know. Unlawful pressure. Somebody was holding a gun at my head whenever I did whatever I did. Obviously, I didn't have the intent to do it. I was forced to do it. I was under duress. Okay, and that explains why you did your act. Frees you from criminal liability. Number 6, entrapment. That means you were induced by a public official. Induced by a public official. You see this come out a lot with people that are maybe talking to minors online in those, you know, those chat rooms. Sometimes you'll read about them in the paper. I was actually involved in a trial when I worked at the Commonwealth Attorney's Office in Lexington during law school, where we were trying to prosecute somebody for talking with a minor online. And as it turns out, it was not a minor, it was a police officer the whole time. And what they do is whenever they're trying to put up a defense, they're trying to say, you as the person posing like a minor, you the police officer, you led me to say things that I wouldn't have naturally have said, or you led me to do things that I wouldn't have normally done if I was talking to somebody that wasn't a public official. So you entrapped me. So the prosecution tries to prove that you were trying to induce a minor. You as the defendant, you tried to put up a defense that says you led me to say those things. You entrapped me. You induced me to do certain things that I wouldn't have normally done. Sometimes it worked, sometimes it didn't. In fact, it did work in the trial that I had, where I was helping out. They got the jury to believe that he was entrapped, and he was released of all of his criminal charges. So, number 7, statute of limitations. There's going to be some offenses that if they're not tried within a certain amount of time, then the statute of limitations runs and you're no longer liable for those. It's not very common with crimes. Generally speaking, you can be tried and convicted for most for a long time, but it's still available. So those are some defenses. Again, those are the defenses if you did it, but this kind of helps explain why you did it and that you lacked the intent. And if you don't have the act and the intent, you're done. So in addition to some defenses, there's some important protections found not only in the Constitution and the Bill of Rights, but also just under some case law. So number 1, the 4th Amendment. You've heard this. Before searching and seizing private property, law enforcement must obtain a search warrant. Okay, so before they can search and seize your property, law enforcement must obtain a search warrant. Now, keep in mind, when they obtain a search warrant, they can't just generally search for anything and everything and find all the criminal activity that might be going on in your house. Say they're going in looking for, I don't even know my guns. They're going in and they're looking for a huge gun because they think it was used for a murder. Okay, well, if they search your house, say they come across a little pillbox that's about this big. Now, there's no reasonable belief that they could find that huge gun in this little pillbox. But say they search it and they open it up and they find illegal drugs. Well, your defense attorney is going to argue that that evidence can't be used against you because a search warrant was given to search for that gun and to search a certain area, to search your house, your garage, for a certain thing. So they can't just search generally anywhere and everywhere for everything. They've got to be looking for those specific things. And we'll touch a little bit on that in a couple of minutes, but under something else. But generally speaking, they have to get a search warrant before they can search your property, seize your private property, and they can't just generally search everywhere for anything. So under that, before a search warrant can be obtained, the judge must be convinced that there's probable cause. Okay, probable cause to believe that you committed the crime that they're looking for evidence on. That's so good.
You know, she's sick.
Oh, she's sick. So before the search warrant can be obtained, the police officers and law enforcement, investigators, whoever, they convince a judge that there's probable cause, and then he signs off on the search warrant and it's executed. Number 2, the 5th Amendment. These are your due process protections. So remember, we've touched on due process. Before you can be stripped of your life, your liberty, your property, your rights, you are entitled to due process under the law. So point A under that, double jeopardy. If you've never seen that movie with Ashley Judd, you should watch it. It's so good. Basically, once you're acquitted, you can't be retried. All right, so you've already had they've already had their go at you to get you convicted, and it didn't work, and so you can't be retried. And point B under that is self-incrimination. You can't compel the accused to testify in a way that will incriminate them. You know, that you hear you've got the right to remain silent. Again, we'll hear on that in a minute, but you can't be forced by the prosecution to testify against yourself. You have the right to remain silent and not to testify. And it's just your criminal defense attorney and your call as to whether they think that you should take the stand or not. Are you going to make a good witness, or are you going to just completely land yourself in jail? So you have protections against self-incrimination. Okay, how? And means that and we talked about subpoenas, where the prosecution can subpoena witnesses to come and testify, but that doesn't work with the accused. They cannot force the accused to testify against himself. Number 3, kind of what we talked about with the search warrant, the exclusionary rule. Any evidence obtained in violation of the accused's rights is not admissible in court. All right, so any evidence obtained in violation of the accused's rights is not admissible in court. So those little pills that they found in the pill box that are not yours, whenever they were looking for that big gun that they could not have found in that pill box, your attorney is going to argue that you can't be charged for any criminal activity dealing with those illegal pills because they were found in violation of your rights, because they didn't have a search warrant to search for those in that little spot. And the purpose of this, it's going to be to deter, warrantless procedures, warrantless searches, and following, other procedures. It's all there to protect your rights and to deter searches that violate your rights. So if they know the evidence isn't